this computer.
Online.
Okay, great. And just a little bit about me. I'm an attorney at Zelms, Ehrlich and Mack. We're in the San Fernando Valley, Woodland Hills. We're about 20 lawyers. Years ago, went to Southwestern Law School near Wilshire in Vermont. I've been a lawyer about 18 years now. And, majority of my practice is defending real estate agents. It's through an insurance company, your brokerage has their errors and omissions policy, and it covers you and the brokerage for claims arising out of, some type of issue, some type of mistake that comes up in your transactions. And your attorney's fees, if you are sued, those would also be covered by the policy. I also defend property managers, construction companies, things related to real estate also. But again, the majority of it is defending real estate agents. I'm usually not going out and suing people. It's usually defending people who have, like I was just talking with this gentleman, you're served with a complaint, some lawyer calls you, what did you do in this transaction? That's a situation where you talk with your manager, talk with Peter, and possibly then they would give me a call. And the handout here, so I'll walk through that, and there's bullet points in here, and I'll elaborate on those, even give you some examples. So going into this first page, which we got up on the screen, initially, remember to define your role as the real estate agent, which is your licensed role. And by that, I mean, be careful that you're not acting outside the scope of what you're really licensed to do, what you're really supposed to be doing as the agent. And by that, I mean, you're not giving advice on whether this buyer will qualify for this loan, or what the payment would be under this interest rate. Those are things for the loan broker. Also, watch the line between being a real estate agent and being a property manager. It's really a different function. If being a property manager isn't something that's permitted for you by your brokerage, you shouldn't be doing that also, meaning handling client funds, handling leases of units. It's related to the role of a real estate agent as representing a buyer and seller of a property, but there are differences. So watch if you think you're going to be crossing over from agent to loan broker, property manager. Even certainly don't become a tax advisor. Like, if I earn this much on this transaction, will I have to pay taxes on it again? And you probably know this already, but that's outside the scope of the typical real estate agent function. Your files here, you're preparing an MLS, and you're the listing agent. You want to be selling the property, you want to make it look good, but be careful with the wording that you use in your MLS. Just don't go overboard. And statements like ready to build, or build your dream home, or ready to move in, turnkey property. Be careful with saying it's ready to build, because that means that the property has a certain type of zoning. There won't be significant obstacles to getting your building permits. Turnkey property, that means that, hey, it's really ready to move in right now. And perhaps, it's a vacant house. Nobody has actually lived in it for the last 3 years since the owner has moved out. You may not know, what's the condition of the plumbing, what's the condition of the electrical. So yes, be a salesperson. Yes, present your property in a positive light, but use some caution, or check with your manager about, overstating the characteristics of the property. Your forms, and the purchase agreement, those have addendums, counter offers. But CAR has made it really, I'd say, easy and simplify the task for you. And all the great minds at CAR, with their lawyers and their experience in the industry, they've created the forms that do nearly all the work for you. So what does the buyer need to investigate when purchasing a property? It's in the buyer's inspection advisory. In that buyer's inspection advisory, it says real estate broker, does not make representations about boundaries, about title, about the condition of the property, about, things like soil stability, functioning of plumbing, electrical, all those guts of the house, the nuts and bolts of the house, you're not making a representation, any type of statement about the condition of those things. And that's what the buyer's inspection advisory says. And it tells the buyer, we recommend that you make any investigation which you may think is proper. So you can tell that to your buyer, and then you're meeting with them, you're talking with them, you can say, hey, remember that form that I emailed to you last night, buyer's inspection advisory? In there, it lists the type of inspections that you may want to do on this property. Maybe you just signed it quickly last night, but take a look at it again. And, by the way, when you signed it on DocuSign, or you signed it on that similar electronic system last night, after you signed, you got another email that says, click here if you'd like to download a copy of the form. So tell your client, you've signed all these things in this simple manner, but you can download a copy of it. I'd recommend that when you're asking these questions about the inspections, take a look at that buyer's inspection advisory again. And for the seller's side also, you as a listing agent, the statewide buyer and seller inspection advisory, that form also provides guidance for the seller. So use your forms to your advantage. Another good one is, what are all the possible inspections you could have to do in purchasing a property? There's the acronym, the BIE. If I remember it correctly, the buyer's inspection elections form, and it has about 30 different inspections there, and there's a box checked next to it as to whether buyer elects to do the inspection or not. So provide your clients that form also. You can walk them through it. I mean, you can do it in a phone call. You can go by their house and sit at the kitchen table, walk it through. And the main thing is that use the form. CAR has done most of the work for you already. Disclosures of everyone knows those are, so important. The seller and the listing agent has to disclose all facts materially affecting the value and desirability of the property. What really does that mean? It means it is kind of vague, but it would have a significant effect on the value of the property. So, if the property is a hillside property and, they're Los Angeles, whether it's Pasadena, whether it's the San Fernando Valley, there's hillside properties. And, so this hillside over here, it's pretty steep. The soils look unstable. Sure. Nobody wants to have a landslide years down the road at the property. So certainly something that affects the value of the property. A noisy neighbor, not totally clear, but people like to have a quiet home. So yes, neighbor issues, that is a material fact. It does have an effect on the value of the property. The disclosures, of course, we know the transfer disclosure statement, which in most transactions is required by the seller, and the seller property questionnaire, which it's also customary to use the seller property questionnaire. You'll see on there, of course, there's the boxes for the seller to check and to give explanations. The important thing to remember on your TDS and your SPQ is that the yes and no and explanations, those are done by the seller. The real estate agent should not be checking those boxes. The real estate agent should not be writing in the explanation. I even say the phrase, like, let's not have your fingerprints on those documents. I mean, you can touch them, you can hand them to your seller, but if there is a claim and buyer says, this building restriction wasn't disclosed to me, this mold in the wall that seller knew about, that box wasn't checked, it will be a more problematic case to defend if the testimony comes out that, well, I went to my client's house and I filled out all the boxes, or I took the TDS at my office at Coldwell Banker. I filled out all the boxes. I wrote in the explanations and I took it to my client and they looked at it and they signed it. That's a problematic situation. So who knows more about the property, the listing agent or the property owner, the seller? Obviously the seller. you know, when you get into explanations and even into your Avid, at the bottom of this page, under 5D, I've got these quotes like, let's say you put on your Avid, typical cracks. Well, typical cracks, I mean, I'm going to read that to mean these cracks are common. There's no problems. Well, you know, the better description on your Avid form would be cracks in deck behind the house. So you're not saying they're typical, you're not saying they're common, you're just saying there are cracks and here's where they are. Minor stains, you know, you go into one of the kids' bedrooms and the carpet has stains throughout it, and you put on your AVID form, minor stains in second bedroom on the floor. I mean, the buyer or anyone who reads minor there is going to think it's not really a problem, meaning that it's not due to a leak, it's not due to mold that's under the carpet. So why not just say in your AVID form, stains on carpet in second bedroom. So don't make a conclusion about the nature of it, the cause of it. This is the third one I have. Smell in downstairs bedroom when rains. Well, that, you know, it leads you to believe that, well, the smell is only there when it rains. But, you know, well, no one wants to smell in their house at any time, but you put in your Avid, and maybe you got this from something from the seller told you, smelling downstairs bedroom when rains. Just keep the description, you know, simple. Just say it's in your Avid, so that's the day that you walk through. So just put smelling downstairs bedroom. These additional words suggest the cause, and that leads people to think it's not really a problem that's going to bother them or cost them, you know, thousands of dollars of ServPro remediation costs after they buy the house. The second one here, okay. You know, one thing here on the second page, providing prior reports. So you represent your seller. Your seller has a report from a termite inspection that was done 2 years ago. Sure, your seller's going to give it to you. You're going to pass it on, but maybe the seller has a termite report that was provided to him when he purchased the property 5 years ago. He still actually has it in his cabinet in his home office. Should he give it to the buyer now? It's 2023 and this termite inspection report was in 2017. Yes, it still has to go to the buyer, even though it was from when he got it from his seller. And you know, at the end of the seller property questionnaire, there's actually the boxes there that say prior repairs, prior reports. So it's the disclosure obligations go to the history of the property. One interesting issue I like to keep in mind here is you know, a flipper, you know, the developer, you might call it, where you say, you know, in LA, the flipper, they buy the property, they do painting, new appliances, maybe landscaping, they own the property for 8 months, then they sell it again and they list it for $500,000 more. So you get a TDS and an SPQ from this flipper who's only owned the property for 8 months, and everything's checked no, and you know, there's no explanations, and everything looks fine. You're getting this great property, it's fresh paint, but you know, since that flipper has only owned the property for 8 months, what's really important is what was going on with the prior owners. So if you're buying a property from your buyer's agent, and your buyer is making an offer on this property that's been flipped, I suggest you ask for the disclosures that were given to the flipper when he purchased it a year ago. And even reports, say, hey, was there a home inspection report? Was there a termite report? So then you're really getting a full picture of the property. On this page 3 here, under faxes and correspondence, you have the points there. in the document, but what I want to add in and caution you about is what I call, be careful about casual texting with the other real estate agent. So your buyers are looking at a few properties, they all look good, there's wonderful family, and they're actually, they've got some money, they're qualified, they'll be able to buy this property. They're comparing different properties. You're texting with the listing agent on this property, and the listing agent is saying, yeah, here's when the remodel was done, here's when the pool was repaired, this is a great property. Is your client going to make an offer? And that's all in a text. And then you text back, my client has some other questions. They want to know about, can they build a deck on the front of the house to look over this beautiful canyon in front of it? And the listing agent texts you back, I think so, but I'm really not sure. Your client just needs to make an offer on this property. And then your text back to the listing agent is something to the effect of, I'll get them into escrow, then we'll do more of the investigations. I mean, you can do that. That's okay, because, in a hot market, it is good to secure a property, and you certainly have a contingency period within your purchase agreement. And you can say that to the listing agent, but don't put it in a text message. Don't, put it in an email. You can text the listing agent back, hey, let me give you a call and we'll talk about this. You can say that, but when it's in a text message, it shows up later. And the problem there is that it looks like you're not really being loyal to your client. You're not really looking out for the best interest of your client. And that what you really want to do is just get them to buy this house rather than looking out for their best interest. And as the real estate agent, you're a fiduciary, coming from that old Latin word, fidelity, the highest degree of honesty, the highest degree of loyalty and care. So if you're doing something that is possibly pushing your client into the transaction without really looking out for them, it could be viewed, maybe twisted by a lawyer later on into a breach of fiduciary duty. And that these issues, I see them come up a lot in text messaging, because we think that if you say it in a text, it doesn't matter, but it's still in writing. Those still will be downloaded from a cell phone if there's a lawsuit later. So just still be professional and not overeager in your texting with your counterpart, the other agent, because maybe it is a small world. You're a Coldwell Banker, you're friends with the agent from Keller Williams, you know each other, you see each other at the grocery store, so you want to be friendly. It's okay, but still be careful with how you say it, especially if it's in writing. And okay, so the duty of care to your client, the duty of care that you derive from your training, your licensing process as a real estate agent, from your brokerage, from meeting with your manager, from even going to a seminar like this or other seminars that you do throughout the year. And as the real estate agent, important thing to keep in mind here is the things you are trained for, but the limits on your professional duty, really based on the limits of what is the training of a real estate agent, what are the licensing requirements of the real estate agent here. And that means that you are not required to give advice on the legal ramifications of a factual disclosure. So there's a disclosure that this property is in a high fire zone. This property is in a flood zone. I have a case now in San Luis Obispo County. I'll be in trial there in February. And the issue there is that the property, it doesn't actually have the endangered species on it, but it's vacant land, and it is legally considered habitat for an endangered species. It's beautiful up there. The mountains just flow into the ocean, and it is considered habitat for an endangered species. Perhaps here you're in a more rural area of Los Angeles County. If you travel out somewhere and maybe it's in Riverside, maybe it's in Ventura County, there is vacant land and there's some kind of environmental restriction on the property there. So the disclosures made by the seller that this property is habitat for an endangered species, that's a disclosure of a fact, but what does that mean? Those are legal ramifications. In that situation, you should tell your client and confirm it in writing that I recommend that you contact a real estate attorney to determine what are the legal consequences of this zoning of the property, of this endangered species on the property, of it, having this building moratorium. And that, it could even come up in the context of recommending an architect, recommending an accountant. Again, recognizing the limits on your duties as the real estate agent, your experience as the real estate agent, not putting yourself out there too much in terms of the advice and the knowledge that you're conveying. Another interesting and common issue that comes up here is permits. People are buying a house and they want to know, there's been a remodel, what are all the permits that this property has? And you're the agent, you want to serve your client, you want to have the sale go through. So there's a desire to say, I'll figure out what all the permits are for you, or I'll research the building permits. The better approach here is to, let's say maybe you get a TDS that discloses a remodel to the second floor has been done, but the box is checked that there's not all the permits. So you want to research permits, but how is that done? Who does it? You should recommend to your client that they research the permits for the property. Put in an email, say an email, based on box C4 of the TDS, I recommend that you research building permits for this property. Well, what does that actually mean? Does it mean the buyer does it? Does it mean you do it? Does it mean you both do it? So there's permit expediters. There's a website, permitreport.com. That's a permit expediter company. So you can recommend that they have a permit expediter pull the permits for that property. That's the best way, the most efficient way to do it. You can, give them a link to the city's website. Maybe your buyer comes back and says, well, I really don't want to look through the city website myself, or I don't want to have to hire a permit expediter to do it. Can you contact the city for me? Well, in that situation, I recommend that your response is, I'm really not an expert in permits either. Why don't we do a call to the city and we'll both be on the call? So it's not that you're going to call the city yourself, or, you're telling your buyer they got to call the city themselves, but you can both be on a conference call with, you can call into the planning department. If you get someone on the phone, you can conference in your client. Or, if you want to look through the websites, you could say, we have this website from the city. I'll come over to your house. We'll go through it together. Maybe your client says, I want you to, maybe it's a smaller city. It's like Santa Monica or Manhattan Beach, and you can actually go down to City Hall, and there's a building department with a help desk, and you can actually talk with someone. So maybe your buyer says, hey, would you go down to City Hall for me and check out the building permits? You can say, well, why don't we do that together? Why don't you go to City Hall? I'll drive down there with you. So we'll meet there. We'll meet on the steps at his City Hall next Tuesday. We'll both talk with the building inspector, the planning department official together. And that way it becomes something collaborative, something your client is doing and that you're doing with your client, rather than Yeah, I'll research for building permits for you and I'll let you know what I find. So the case that I just mentioned a moment ago in San Luis Obispo with the endangered species on the property, in that case, the buyer wanted to build a home on the property. So she wanted to know, and this is a complex area to build in. There's the county, the coastal commission, and there's actually also the issue in this case is U.S. Fish and Wildlife has jurisdiction over this property also. So it's even harder than if you were gonna build here in Alhambra or Pasadena, even more difficult. So this buyer said, can I build my house on this property? I want to build a house for me. I want to build a guest house to have my elderly parents in, sort of my dream home that I'm going to live in. And she said, will you check out the building requirements of the county of San Luis Obispo? And this agent said, sure, I'll contact the county and figure out what we need to do. So he contacted, he's well-intentioned, he's a good agent, well-intentioned. He contacted the county. He talked with the county planning official, and she told him, you need this building permit from the county, and this property is in an endangered species zone. So you have to do a biological survey before you could build on the property. If the biologist finds that there are actually endangered species on this property, in this case, it's so silly, it's an endangered snail. It's not even a real animal, but it's and so the county planning official tells the buyer's agent, if the biologist finds this endangered snail on the property, then you have to contact U.S. Fish and Wildlife Department and go through a habitat conservation plan process with them. So this real estate agent, maybe he's taking some notes, he's listening carefully. He gets off the phone with the planning official. That same day, he sends an email to his client buyer's agent. He says, here's the scoop. I just talked with the planning official. You need to get this permit from the county, and you need to do a biological survey for the snails. If the biologist finds that there's snails on this property, then you have to go to U.S. Fish and Wildlife and go through another study and get your habitat conservation plan. It sounds like it's not a big deal. So he puts at the end of his email, it sounds like it's not a big deal. So this lady buys the property, she gets her construction loan, she applies for a building permit through the county of San Luis Obispo. They're okay with it, but when the county issues the permit, they also, I'll say, flag or notify U.S. Fish and Wildlife that there's going to be building on this property. So U.S. Fish and Wildlife stops the issuance of the permit. This property owner has to go through a 2-year process of biological studies, habitat conservation plans, public notice of these plans. 3 years later, she can finally build on this property, but now she sues her real estate agent. She says that, real estate agent, you didn't investigate this property. You led me to believe there weren't going to be building restrictions. And one of the things her lawyer holds up in his case is this email where he says to her at the end of it, if you have to, go to U.S. Fish and Wildlife and get the habitat conservation plan, it sounds like it's not a big deal. So that agent, he probably did too much. He took it upon himself to become the permit researcher and really to become a land use attorney. And if he had had his client involved in that, hopefully he wouldn't be in that situation now. So if he had said, I'm calling the planning department I've got an appointment, maybe he calls or emails in advance and says, I'd like to have a call on Tuesday at 10 a.m. If he told his client, I have a call with the planning department official on Tuesday, February 10th at 10 a.m., I'll conference you in, then she would have heard what the planning department official said direct, the phrase straight from the horse's mouth. She heard it directly from the source of the information, rather than the real estate agent's take on it. So the main idea here is to not take on the responsibility of being the permit researcher. Give your client the resources, give them the link to the city, give them the phone number, bring them to, when you walk down to the planning department at City Hall, be sure they are there with you. Don't take on that responsibility yourself. And yeah.
Right, I hate to interrupt, but I have a question regarding the detail of disclosure. How can the email that the agent sent to the buyer saying that they have to go through the environmental, not but the coastal commission, right? I'm not-
U.S. Fish and Wildlife.
Yeah, wildlife, yeah. And actually you have disclosed to them that that it's their duty, or the buyer's duty to investigate
Mhm.
further. I mean, he already discharges the disclosure duty, but how can it be a negative effect on the lawsuit when it comes to the litigation?
Well, one, I think I'm gonna win that case. So, so the idea that you still get caught up in these cases and they take up, 2 years of time, but still at the end of it, you still are successful. And I think that ultimately the jury will find that the agent fulfilled his duty, but, the theory that the plaintiff and her attorney have used is that it was a negligent misrepresentation by the agent. And really he said, it sounds like it's not a big deal. That's what they have latched onto as a negligent misrepresentation by the agent. So the other thing there, that in that case, the other issue is that the agent, he did a complete job of researching with the county, but he didn't contact U.S. Fish and Wildlife. So it's kind of like when you get into researching permits, maybe you don't know every agency that you have to contact. So you're buying a house, it's San Luis Obispo, it's Santa Barbara, or it's Malibu. I mean, maybe it's the city of Malibu, the county of Los Angeles, the Coastal Commission, and U.S. Fish and Wildlife. So, you take on this responsibility, but then you miss one of the agencies, and it turns out that's the agency that stops the building process. So in that situation, that agent, he had also sent that client an email that said, I have a friend who's an architect who builds a lot in this area. I think you should talk with him. So I'm going to use that email to say he was recommending someone more specialized to assist this buyer. What would really make my job easier is if he had sent the email that said, I recommend you contact a real estate attorney. So he did a somewhat good job by saying, I know an architect in San Luis Obispo who's very familiar with this area. I recommend that you talk with him. Here's his phone number. I like that. That's going to help us with the case. One step further, and even a better job would have been to say, I also recommend you contact a real estate attorney. And, when you make these recommendations, it's to put the icing on the cake. The even better way is that you say, I recommend you contact a real estate attorney. Here's Joe in Pasadena, here's Steve in downtown LA, here's Mary in Glendale, and here's their phone number. So you're not leaving it to them to search, so yeah.
So if he countered, why do I need to contact a real estate attorney? What will you answer?
Well, your answer would be that, building restrictions involves legal issues, and those are not something that I'm knowledgeable in as the real estate agent. I'm here to help you, find a property, determine what's a good offer price, help you with the forms, and, help you with escrow, things like that. But, you can even just say really simply, I'm not an attorney. These are legal issues. So, yeah, sure.
I have a question. We have like trees here, like that can block people from doing some expansion. But like me, I think it's oak, right?
Oak.
I don't know what kind of tree I'm looking at. I cannot identify them. So because we do have oak trees here.
Mhm.
What would you recommend on that to come and check it? Just a tree botanist or?
Well, I mean, if, first of all, maybe talk about them, are they planning to build around the tree? If they tell you, I'm buying this house and I want to expand out into the whole backyard,
Right.
then you can say to them, some of the trees have restrictions from the city. I really don't know what tree this is, so here's an arborist, have the arborist come out and take a look at it. It's not really a common inspection to make in a transaction. People are doing termite inspections, people are doing home inspections. That's a less common inspection. Ask your manager if they have a number of someone. If they don't, I would, do a Google search and find an arborist, have them come out, just like while all the other inspections are done, have the arborist come out. So they come out and they say it's a tree that is, protected by the city. So in that situation, recommend to your client that they contact the city and determine what are the restrictions on this tree. And, there you can say, your email, here's the city's website, here's the city's phone number. I recommend that you contact them. And they say, oh, I don't really understand. I don't want to do it. Would you do it for me? Well, I'm really not an expert in that either, but if you like, we can make an appointment with the city. We'll both go through there together. But be sure that your client is with you, and be sure your client is listening and involved. So it's not like you're meeting with the city and then you're telling them what you heard. So, yeah.
When, what if they intended to be their primary residence first?
Right.
And then a few years later, they decided to build and find out that there's a whole lot of restriction
Mhm.
on the trees that was planted in the property.
Mhm.
What is the statute of limitations that they can make the claim? How many years?
Right. So if you're a buyer's agent, you're a fiduciary. So as a fiduciary, because the law is a little bit tougher on you if you're a fiduciary. So there, the general rule is it's a 4-year statute of limitations for what we call breach of fiduciary duty. If you're sued by someone who's not your client, like the seller for negligence, like, maybe the buyer sues the listing agent, says the listing agent also made some kind of comment which wasn't careful, that was negligence. If you're sued by the other side there, it's 2 years for professional negligence, not a fiduciary. It's 2 years. If they claim that you actually intentionally misrepresented something, then, fraud, then it's usually 4 years for that type of claim. So in the idea there, with, the law allows people a time period to bring their claims. So to keep in mind there is, save your files, well, you're probably required to provide some of your documents to your broker. And then you probably also maintain your emails and your text messages yourself. I know the text messages are harder to maintain. I mean, I don't myself have every text message from years ago. But your emails, you should be able to store those pretty well. And so, keep those for, if you could, at least, 5 years, if there's some way to archive them. And, hey, what I was just saying about, I don't even have all my text messages, but I have a lot of my emails. So on the more important issues that come up in a transaction, you can communicate with them by text, but to be more careful, put them in an email rather than a text, because it'll have that date and time stamp. It'll also show your signature block, real estate agent Coldwell Banker George, to know that you sent it. It will have a little more professional of an appearance and make it a little easier to deal with if there's a claim. Let me see what else I wanted to. Please, yes.
Well, we have a lot of people that we, as real estate agents, that come into the office and talk to us, and they're doing this type of work and that type of work. Just say, for instance, the tree. We might have 4 or 5 people that can tell us what type of tree that we're talking about.
Mhm.
You follow me?
Yeah.
So when we're telling our clients, should we pick out and say, well, here's one, or just give them a list of the client, people that do that work,
Mhm.
and let him decide on which one he wanna use?
You
And
know,
then if we have to go with them,
Mhm.
then we can do that. But never tell them, say, use this one or that one, you know what I'm saying?
You know, if I was making a recommendation on your arborist for the tree, I'd give them two names and say, hey, these are both good. Maybe maybe you haven't used them before, so you wouldn't say, oh, these are great arborists, because you say you did find them on Google, okay? Because it's not really a common inspection.
Right.
So you found them on Google, just, say, hey, I did an internet search. I found these two arborists. Give them a call. And then your client can pick the two of them and see, who sounds better on the phone and who has the better rates and availability. I mean, do you pick one or do you give them a list? There isn't a magic rule on it, but I can tell you, you're not required to give them a list of 10 arborists or 10 termite inspectors. That's not at all expected. So, sometimes the managers have a list of inspectors. So probably your manager has a list of termite inspectors.
That's what I'm.
Probably your manager has a list of sewer inspectors. Maybe your manager has a list of contractors.
Mhm.
Some to look at. Maybe your manager has a list of plumbers or electricians, those kind of things. So, yeah.
Because what I'm saying is, because if the client is upset
Mhm.
about the tree, now she's finding out the tree is
Right.
there and she can't deal.
Mhm.
And what if she go ahead and do something and then come back, well, my agent gave me that list to call and they didn't give me the right information. You
Well,
always bring it back on the agent still.
right. So there, again, you want to be careful with how you word your email. You don't say in your email, this is a great inspector. All you could say is that, this is a home inspector who I've used before. This is an arborist who I've used before. Or you can, hey, you find them online and you're sending your client an email. You can even just, like screenshot or copy and paste over what you found online about the person, about this inspector, this arborist, this plumber. And then you can say, hey, here's the arborist I found online, and give them the screenshot or the copy and paste. So you're really just pointing them to the information. You're not yourself representing that this is the top inspector. And that, I think that raises another good issue about, the information that you provide to your clients. Like, let's say your client asked, what's the square footage of this lot? So, and you would not want to say to your client, it's 3,012 square feet. What you'd want to say is that I looked at the LA County Tax Assessor's website, and according to the LA County Tax Assessor, this property is 3,012 square feet. Here's a link to the LA County Tax Assessor's website. I haven't confirmed this information myself. I'm telling you what the LA County Tax Assessor's website says. And hopefully you see the difference there between,
Right.
I'm not saying it's 3,012 square feet. I'm telling you what the LA County Tax Assessor is reporting on its website.
Right.
It's government website. It's public information. So therefore, there's a kind of a rule or a principle with being a fiduciary that you provide information to your client and you confirm its accuracy, or you tell your client that you haven't been able to confirm its accuracy. So in this situation, by telling your client the source of the information, essentially just copying and pasting over what's on the government website and telling your client, I'm simply giving you what's on the tax assessor's website, there you're really not making a statement yourself that this is the square footage of the property. You are telling them what is on the tax assessor's website.
Right.
So hope you all, see the difference between those two situations. The one where you are telling them what's on the tax assessor's website is the safer way for you to go. And then use the technology to your advantage. Copy and paste the link from the tax assessor's website. Screenshot it from the tax assessor's website. That's the manner of communicating with your client, which will protect you. So, okay. Let's see. Anything else? Okay, I get off my slides, but that's even better than me, reading through my slides with you, having a conversation with you about these issues. But just to somewhat go through these slides there's a page 5, and actually there's one about negligent drafting. It says, so maybe, you have your CAR form and there's amendments to it. Common amendments are extend contingencies. Maybe I'm seeing a lot of cases where buyers are providing higher deposits, and then they're saying these deposits are non-refundable. If you're the more involved these amendments get, contingencies, when are they removed? When are they extended? How much of a deposit? Is it refundable? Is it not? In what circumstances, is it refundable? Like it's a small apartment building and it's not refundable if it is refundable to the buyer if the seller cannot deliver the unit vacant by close of escrow. When my point is, the more complex these amendments get, it's kind of like you're drafting a contract. So talk with your manager about those. If your amendment just says close of escrow is extended another 15 days, yeah, go ahead and draft that. But the more clauses and extensions and if this, if that, check those with your manager. Liquidated damages on the bottom of page 5. If you are the agent that submits the purchase agreement to escrow to open escrow, like you're the last one that has it, and you submit it to escrow, double check that the box about liquidated damages is initialed by seller and buyer. I have a case where there are different versions going back and forth, and the listing agent submitted it to escrow, and seller had initialed the liquidated damage clause, buyer had not. Then problems arose, there was a lawsuit, and basically everybody's been sued because that box wasn't, I think it's 29 under the new purchase agreement, and that limits the buyer's exposure if there is a lawsuit, but it's only valid if seller and buyer check it. I said initial it. So just double check. If there's one thing you're going to check on a purchase agreement before you email it to escrow, check that both sides have initialed that liquidated damages clause. Yeah.
One of the procedures that I implemented that has kept me out of trouble is that whenever there's a document that has to be signed by either the seller
Sure.
or the buyer or both, before they sign it, I take it to the branch manager. I've taken the document to the branch manager who reads the document and points out to me any errors and omissions that I, as an agent, may have overlooked. That has kept me out of trouble because the branch manager has an independent set of eyes and can say, you forgot to do this, you forgot to do that. And
yeah, sure. You use your managers to help you out with these forms. There's less, you always use the offer, maybe the counter offer, maybe a cancellation form, maybe you use that once every couple of years. So, you check with your manager about that one. Liquidated damages, in a residential transaction, it's 3% is the standard provision. But if someone wants, maybe if it would be seller that wants it, if seller wants it to be higher, first of all, be careful. That's kind of a signal that this might be a weird transaction. And 2, talk about that with your manager. Because there's different issues that come up as that liquidated damages amount is increased.
3% of what?
Of the sale price, yeah. So maybe so the higher value of the home, the higher number that increases. But if a seller asks for a higher amount, it should light up a caution sign. in your transaction. I'm not saying don't agree to it, but use more care. Yeah, right, yeah. Let's see. I'm on page 6, just MLS areas of concern. Keep in mind your MLS, you're responsible for the accuracy of what's stated in there. So be a salesperson, but don't over exaggerate the language, and you don't need to talk about whether something is permitted or not in an MLS. It's not the place for it. Let's see. I want to move ahead to page 9 because I really like to talk about the breach of fiduciary duty. And I mentioned it already, but I think it's so important that you understand it again, that maybe I'll even talk about it too much or again, but it is the duty of utmost care, utmost loyalty, and utmost good faith with your client. And the situations that I've seen where this come up is, what's your financial interest in the transaction? And the rule, the one you can put on that Post-it in front of your computer, is that anything that any dollar you earn from this transaction has to be disclosed to your client in writing. So, I mean, the most obvious one is that you're dual agent, that has to be disclosed. That's, of course, common that everyone discloses that. But, I had a case where listing agent is representing an elderly lady, older home in Hollywood. There's an offer. It's from a flipper, pretty aggressive guy. He's making offers all over. He buys these homes, and within a year they're flipped, and he's selling them for more. But his thing is that he always offers a listing agent an extra amount of money, like outside the commission. Every time he buys, he'll give the listing agent, say, an extra $2,000 just as a payment directly to the agent, and it's outside of escrow. So it doesn't appear on the closing statement. So this agent, it wasn't in this office. He was in one of the other bigger offices in Hollywood. So he accepted that fee, and he says, well, I told my client about it, but it was in a phone call. That doesn't really count. It doesn't at all count. It being in a phone call, it needs to be in writing. But any financial interest, any financial benefit that you receive from the transaction, it has to be disclosed to your client. But it's like, if you're really doing a job as an agent and you're really getting your listings, you're getting your commission, do you really need to get that extra $2,000 on the side from the buyer? You really don't. To keep yourself out of trouble, and you'll be closing more deals. You're going to make much more than that anyways. The other thing in this case, and the other common things, hey, you're selling it to the flipper, he's going to sell it again. So he says to you, hey, you'll sell this house to me, and in 9 months I'm going to relist it. You'll be my listing agent. You say, okay, great, yeah, let's do that. I'll be your listing agent again when it's sold. Okay, you can do that, but you need to tell your seller in writing. So have an email where you say to the seller, hey, with this buyer, Joe, you're accepting his offer. Here's the escrow period. Here's the inspections. I also want you to know that he has asked me to relist the property after he remodeled it, and I agreed that I would. So put that in an email to your client. So that full financial interest is disclosed there. Another disclosure issue, which probably you know about it already. I have this coming up in a case now. You're the listing agent, and the property is, it's owned by a family member, like you're selling your sister's house. Totally fine. List a house for yourself, list a house for your sister, your cousin, but, state in the other terms section of the purchase agreement, listing agent is related to seller, or when you make that offer, buyer's agent is related to buyers. The funny thing is that the case I have, and as I was getting ready, I got this call on my cell phone for a minute. It was this case. So the crazy thing that the buyer in that case has alleged, and I say alleged because it's ludicrous. She said that, and the disclosure is listing agent is related to seller. She said, well, that's not good enough. You have to say You have to state the precise relationship. You say, listing agent is the seller's cousin. Listing agent is the seller's uncle. You're not required to go that far. So amongst all the things I've told you you need to do, here's one that you really don't need to go that far. Saying listing agent is related to sellers is sufficient. You don't need to state listing agent is seller's cousin, or something like that.
Hey, Brian, if asked, are you obligated to disclose that information?
Yes. If certainly, if you're asked about it, give a truthful, response, and you should actually disclose it without being asked. So it should be somewhere on the offer or even on an addendum, like, hey, you don't put it it's not in the purchase agreement. So a few days later, just put an addendum that says listing agent is related to seller and get both side signatures on it.
Oh, I meant as far as the specifics of the relationship.
Oh, if you're asked about it,
Are you obligated to disclose? If
I
someone
mean,
asks, let's say you're the buyer's agent,
Mhm.
says, well, what kind of relation, and you're asking, what kind of relationship are you to the seller? It's like, are you obligated to tell them that, hey, what's my wife or my brother or my sister?
you should. Yeah, if you're asked about it, state the precise relationship, sure. The other way that this comes up is, hey, you're the listing agent and the home is owned by an LLC, again, a flipper that remodeled it, and you're a 20% owner in that LLC. So you should disclose that also. Listing agent is an so put on an addendum or somewhere like in other terms on the purchase agreement or in a counter offer, just put listing agent is owner. Say listing agent is partial owner of LLC, which owns the property, something like that. And just getting to the end here, like I was talking to this gentleman before we started, so you learn that there's a potential claim, or say after the transaction closes, an attorney contacts you. You were the listing agent, and an attorney contacts you, say a year after escrow close and says, hey, I want to be able to get a copy of all the disclosures that were given on this transaction. Say, hey, can I get a copy of the TDS and your avid? So, tell that attorney, just because, first say to the attorney, is there a lawsuit? So try to get out of the attorney, is there actually a lawsuit? And then say to the attorney, before I give any information out to someone who's not my client, I need to talk with my broker. And also maybe the attorney gets you on the phone and starts asking you questions about, so what did you see at the property when you walked through it? What did you say to the buyer during that open house? In that situation, say to them, well, since you're an attorney, I really don't feel comfortable talking with you without letting my broker know first. So in that situation, you're protecting yourself, because there is, somewhat of sort of a way that attorneys will twist your words, kind of that difference in knowledge of the situation that the attorney may try to use against you. And then also with regard to claims that come up, and this really more something for your broker, but you want to try to resolve them early. And like I said before, save your documents, save your emails, save your text messages as best as you can. And gone through the basics of my outline. Any other questions, anything else you just want to talk about? I'm not in a rush to leave, so talk about anything else.
Brian, you mentioned that it's going to disclose one of the parties that your buyer, your client, is a flipper. So how do you define a flipper? Is it 3 months, 6 months after the sale of the property? And do you have the obligation of additionally to disclose, to find out whether your client is a flipper or not?
So I would say, first of all, one thing I like to know when I'm buying a property is, like, is the property occupied right now? You know, if the property is vacant right now, if the property is vacant, you know, you go there for the showing and it's an empty house, or there's like, you know, there's staging in part of the house and the rest of it's open. You know, a vacant house, that could be a sign it's a flipper. It also is just a sign that you need to be more careful. Because, you know, if there's been a leak in the roof and someone's living there, they're gonna know about it. They're gonna repair it or they're gonna disclose it. But so the first thing I keep in mind is be more careful with properties that aren't occupied. Be more careful with properties where the seller has owned it for less than a year. So it's perfectly legitimate question to ask the listing agent. When did the seller buy the property? And actually, who is the seller? So if your seller is someone who's owned it for less than a year, or your seller is someone who is what we call, you know, a business entity like an LLC or a partnership, then those are signs that it's probably a flipper. And then, you know, say you're on the other side, you're the listing agent. I mean, as a listing agent, it's not like you must ask, are you a flipper? But you should know your seller, and you should know the background of the property. So if your seller has, you know, owned the property for 20 years and you know, every single box on the TDS is checked no, you're like, hey, there's never been a leak, there's never been any noise, there's never been any, you're telling me you lived in this property for 30 years and you've never done any repairs to this property? You know, I mean, I said an hour ago, have your seller fill out the TDS, not you, and I still mean that, but your seller's owned this property for 20 years, 30 years, and they've checked no to every single box, and they've given no explanations on the TDS. I think that's a little bit funny. I think that's a little weird. So there, ask your seller, so, you know, I see you check no to every single one. Are you sure you've never done any repairs? Are you sure there's never been any termites at this property? Are you sure there's, you know, never been any sort of, you know, noise in the neighborhood, things like that? Those would be kind of, you know, red flags. You know, I guess last interesting story I'll tell you about is that, you know, I had a case, it's in Orange County. And, you know, it's really nice old equestrian neighborhood there, you know, 2 to 3 acre lots. And the listing agent, you know, she's doing her open house. The buyers come through, husband and wife. They're kind of, you know, older conservative folks, and they're looking all around, they're asking all kind of questions. And the wife asked the listing agent, so how's the neighborhood? And you know, listing agent says to her, oh, this is a great neighborhood, the neighbors are great. And a month ago, the listing agent had also been a listing agent on the house next door. Man had lived there for 30, 40 years. He sold it to an LLC, which operates group homes for troubled teens. You know, they're recovering from mental health or drug abuse situations. So the house next door was going to be used as a group home for these teens. And the law was, you know, the law is that if it's up to six beds in the house, you can do it in a residential neighborhood as long as you go through the permitting process. So these folks, they've heard the listing agent say it's a great neighborhood. They bought the house, they moved in, you know, months later, the teens are in the house, they're jumping over the fence into the backyard. There's noise all the time. At least once a month, the police or an ambulance is called to the house. And there's the staff, all the counselors, the therapists are coming into the house. So there's like 20 cars parked in front of the house every day. So they file a lawsuit against the listing agent, saying that your statement that the neighbors are great was a misrepresentation. You know, and there was some dispute about what was said, but I think that the agent's comment was, the neighbors are great, the seller is friends with the neighbors. So they said that was a misrepresentation. Here's what I learned from that. So if you're asked about the neighborhood or the neighbors, just say that it's a great neighborhood. don't make a reference to a specific property. Don't say something like, the neighbors on the south side of the property are great, or the neighbors at 814 Hill Street are great. Just say it's a great neighborhood, you know, because the way we defended that case was by saying that, well, that's a statement, that's just someone's opinion about what's a great neighborhood. And it's so vague. I mean, what's a great neighborhood? What's a great neighborhood to me could be different from what's a great neighborhood to you. What's a great neighborhood to you? So we defended that case as saying that it was really an opinion. It was great. You know, that's a great neighborhood. It's kind of vague. And also that, like, you know, we kind of tried to make the buyer look a little bit like they're, I guess the word would be like elitist, like they're saying that, you know, these teenagers in the home, like automatically there's something wrong with them, you know. And, you know, that really it was just a general statement that it is a great neighborhood. And it really was a neighborhood where people have horses, you know, people are living there 30 years in other homes, the kids are growing up there. So it really is a great neighborhood. So if you get a statement, a question about, so who's the neighbor in that house? You probably don't know, just say, you know, I really don't know. Or you could even be as direct as saying, I really don't know, but if you'd like to, you could walk up and knock on the door and try to meet the neighborhood during the neighbors during the escrow period. I mean, you know, they can do that amongst your investigations. I mean, everybody thinks investigations are check for mold, check for home inspectors, but a buyer is allowed to knock on doors during the neighborhood and meet the neighbors. So yeah, don't refer to a specific property. Just say it's a great neighborhood. If you're asked about it, I mean, unless you really think there's problems with it, then say what, you know, problems are. But if you really do, as in most situations, think this is a great neighborhood, just say generally it's a great neighborhood, and that's a defensible answer.
Going back to the flipper scenario, you know, on the buyer side, when they ask for reports or repairs done prior to the, let's say the flipper that had it for 10 months, less than a year, is that seller obligated to retrieve those reports or not? Because he's only had it for 10 months and his knowledge is for those 10 months, right?
If he received them.
Okay.
So if he didn't receive them from the seller, he doesn't have an obligation to go out and look for them from other people. But if he received them, then he has to give them. So,
Yeah, 'cause a lot of the times these flippers will buy a property
Right.
in distress and it's as is.
right. Yeah, and they don't do much inspection themselves. Yeah. So yeah.
So they're only obligated during the duration of their ownership.
Sure. Yeah.
My quick questions on the PDS.
Yes.
So if the seller check something there on the PDS disclosure, you should make explanation, right? Should explain why.
If you check yes, there's the explanation section below, and the seller should give an explanation. You know, like the bathroom had a leak 3 years ago. It was repaired, something like that.
That's it, right?
You know, I mean, you don't. I mean, if there's, that should be enough. I mean, if there's if there's more information, which is, you know, really material and is important, you can give more, but I say definitely you do use most of the time, the explanation section, which is pre-printed on the form, is enough. So. And by the way, then that puts the burden on the buyer to investigate, because you know, we're hard on the seller side. You got to disclose this, you got to disclose this, but the buyer has a duty to investigate also. So when you check that box and your seller puts in 2 lines of explanation, the ball is now in the buyer's court to do their job.
And the second thought on the BIA, the buyer's inspection advisory.
Right.
If I'm representing a buyer on the fiduciary, he will ask, okay, if he asks me on this one, I gave it to him, the BIA. If he asked me, hey, my friend, agent, can you advise me which one I have to do?
Oh, on the different inspections there.
What do I say?
So, I mean, every escrow, there's the general home inspection. The termite inspection is also pretty standard. I'd say it is standard also. And, you know, after that, first of all, you know, you want to ask the buyer about, you know, how they're going to use the property, if they want to remodel it, if they're going to rent it out. So try to get some information about how they're going to use the property, but then also look to the disclosures. Because look for what red flags come up in the TDS and the SPQ. Use that.
I have a question regarding the fiduciary duties of the broker. Is there a different standard for a broker and the agents? Any difference between the broker and agents?
I mean, because the broker is just kind of, you know, the legal word vicariously liable. You know, your broker is automatically liable for your mistakes during the transaction. You know, and thankfully, that's why the brokerage has insurance. So, I mean, for the broker, it's that automatic liability. And then there is also, you know, of course, that, you know, duty of supervision, you know, and you're not following your agents around on the transactions, but you're being sure they have the forms, they turn in offers to you, and you meet with them or you hold seminars, things like that.
Okay, thank you.
Yeah. You have something? Hi.
So if I had said something like, according to the Bob the plumber,
Mhm.
he said that there's nothing wrong with the pump.
Mhm.
Right, and if I said something like that, then there is something wrong with the plumbing, then I'm liable.
Well, no, is no. So if you're putting that in an email, say, you know, Bob the plumber has told me this, you know, I can't confirm that myself. I'm telling you what Bob says. Okay, so that will help you. But remember, inspections generally have a report that is generated, but maybe Bob the plumber doesn't generate a report. But try to, so here's a good rule to keep in mind. The people who do inspections, ask them to create a written report. And the home inspector does that, the termite inspector does it, but maybe Bob the plumber doesn't do that, okay? And he says, oh, come on, I don't want to write up a written report for you guys. So, okay, Bob, would you send me your thoughts in an email? So do that, and then you can click forward to your buyer. Hey, here is what Bob the plumber is telling us. So, yeah.
Absolutely worst case, if we get, you just say based on Bob the plumber's.
Right, yeah,
Conversation. this is
sure.
What he told me.
Yes, that's okay.
On
I
a
mean,
worst case scenario.
On a worst case scenario, but that's better. That's obviously, that's in contrast from you saying this leak has been repaired.
Right.
So if you send the email that says there was a leak 2 years ago, it's been repaired, then, you know, you're saying that, but in that worst case scenario, you say, you know, based on, you know, or you know, according to what Bob the plumber has told me, it's been repaired. And then, you know, maybe you can say, you know, here's the email from Bob, or here's Bob's phone number if you want to talk to him yourself. So,
But what not to do is just, you know, text or email your client, say, plumbing's good, you know?
exactly, yes, exactly, yeah, that's it, yeah.
So I'm just trying to think of like, if that made me liable,
Mhm.
then wouldn't say, according to the tax assessor, the square footage 3,012 square feet, then that doesn't make me liable, then that's where I was confused, but you're kind of saying the same thing, so either one, I would say according to some other source,
Sure,
then I.
sure. And so, you know, push that source to put it in writing themselves in a report or in an email, or, you know, you can't call the tax assessor and say, tax assessor, write this down for me, but you can copy and paste information from their website. You know, you can give a link to their website. So, yeah.
Hi, this is Teen. What if you hear some information from your neighbors? Do you have to disclose that?
So is this like you're the listing agent and the
Yes.
seller? So there's your listing agent and the seller has information from a neighbor, and the seller then tells that to you. And, you know, let's say that the information from the neighbor is that, you know, maybe there's a factory down the street that, you know, when it's windy, there's fumes and the air spreads those. You know, maybe there's a smell in the neighborhood then. So I think your first question to you is, you know, to your seller, well, have you ever smelled that in the air in the neighborhood? And if your seller says no, then, you know, you're just dealing with the neighbor, with what the neighbor said. If your seller says yes, then, you know, obviously, that's a material fact that has to be disclosed, you know, to the buyer. You know, all facts materially affecting the value or desirability of the property, you know, having a significant effect on value, and, you know, desirability, you know, is this a, you know, a healthy, safe place to live?
Yeah, sometimes the neighbors lives longer than the owners, so they have previous information that the seller is not aware of,
Mhm.
and they come to you and tell you something in the past about the property. Do you have to disclose it? Do you have to take the neighbor's words?
Well, you know, so err on the side of disclosure, you know, err on the safe side, err on the side of disclosure, and disclose that. So if a neighbor has come, let's say the neighbor comes to you directly, that makes it even a stronger argument that you should disclose it. So the neighbor who comes to you directly and says, you know, I'm having these problems with another neighbor, or, you know, there's this, you know, fume in the neighborhood in the air, you know, in that situation, you know, there's a section on your Avid, for, you know, other information that you know about the property. So put on there that, you know, neighbors have complained about X, Y, and Z.
Now, what if, when that occurs, and let's say the neighbor, directly, I'm the listing agent, the neighbor sees me come in, I'm doing open house, and comes and talks to me directly, and tells me a similar situation as what you just spoke of.
Mhm.
Do I have to discuss that I have to discuss that with the seller first, right?
Sure.
And what if the seller says, no, I don't want that disclosed?
Good question. Yeah, I mean, that's a tough situation for the agent there, because right, that's the relationship. So, you know, I mean, your duty is to your client. The duty to disclose is on the seller and on you. I would still, well, again, you know, we want to know,
What if the
you know,
what if the seller said that, well, that's what he said, but I've never witnessed that,
Mhm, mhm.
right?
Right,
It's the seller that's selling it, not the neighbor,
Mhm.
but now you're in a pickle there.
right. You are in a pickle there. Well, first, so go talk with your manager, you know, go talk, you know, talk with Peter. Yeah, well, you're the manager. That's right. Yeah, I forgot that. Yeah. Yeah, that, and I mean, in that situation, the agent, I mean, a lawyer could make the argument that the agent has knowledge of information, that was, you know, material to the property. So, I mean, lawyers will come up with any kind of crazy story, any kind of crazy argument. But, you know, if there's really information, I mean, let's say if there's really like well-founded, meritorious, if there's valid information that you know of, even if your seller doesn't know of it, or even if your seller says, I really don't think this is true, as the agent, you still have a responsibility to disclose. And I'd say in that situation, you should still make some disclosure of it. Yeah.
Yes, something like, for instance, the seller has no knowledge about previous incidents in that house, maybe bad incidents like maybe murder or anything like that. But the neighbor has that information and give the information to you maybe during open house or maybe because you just talk to the neighbor and seller doesn't know about it. So do you have to disclose that? Because
Well-
if you tell the seller, you might cause a friction between the seller and the neighbor too.
So, look, as the listing agent, you're not required to research the neighborhood. You're not.
Well, we
required
don't
to walk
research,
around.
but they happen to come to you
Right,
with the
okay.
information.
So you're at an open house, the neighbor comes in and says something negative to you about the neighborhood. Your
How
seller,
about the property? I mean, about the property.
about the property.
Yeah.
So you, first of all, you tell your seller, because whatever you know, your client needs to know that also. So one, you fulfilled your fiduciary duty there by letting your client, you'd be really be in a problem if what the neighbor told you, you never told your client. So first of all, do that, tell your own client, then get your client's side of that story. You know, let's say your client says, oh yeah, I've heard that too. So, you know, then you need to disclose it. Let's say, well, your client says, no, I've never really had that problem. I've never really seen that myself. So then you are in a tough situation there. You know, you kind of need to do some kind of balancing of how valid it sounds, you know, maybe how current is this information, how severe is the situation. You know, let's say that it's, you know, something that happened, you know, 15 years ago. Well, then that's outside the scope of what you need to disclose. Let's say you,
Or it could have been one occurrence.
yeah, it could have been one occurrence, yeah. So in that situation, one occurrence, that's not material.
But see, it could also be like a, you know, the neighbor and the homeowner not getting along. and
Right,
Being
sure.
frivolous, you know.
right, it could be, it could
you
be.
know, Maybe not allow the seller to get maximum dollar for their home.
Exactly, yeah, it could be, exactly, could just be that neighborhood, you know, scuttlebutt. So, you know, what the neighbor told you, put it in Google, you know, find out what information you can find out about it. If it's something that I think, you know, I like 10 years as a reasonable period of time on, you know, things that are material for the property. So if something happened after that, it's, you know, less likely to be material. But you know, it's something that happened just a few years ago, more recently, then it starts tilting more towards the material side of it.
Well, let me ask you, let me get a little bit more elaborate on this topic. Let's just say the neighbor is just doing it, you know, saying that this happened, but they don't want to give you any specific information. You know, that would probably bring you to believe that it's frivolous.
Right.
Rather than saying, oh, the neighbor at 5220 always has parties every weekend and stuff, and there's a bunch of cars, and they park on the driveway, whatever, and that's more specific, where you can validate that, right?
Right.
And then, and then in addition to that, would it be, a method of disclosure, could it be like saying that the neighbor just is stating this, but our seller has never witnessed it before, so.
That's good also,
requires
sure.
To do his own investigation.
That's a good way of handling it too. Sure, yeah.
Do you have to put that in writing?
If I have many cases where, you know, it becomes like a he said, she said contest. So yeah, I mean, you say that I told you that, you know, I told you that in the guest room there was mold on the wall, or I told you of the situation with the neighbor. Just in a phone call is probably not sufficient. Yes, you should put it in writing. Yes.
Hi, this is Camelia. I have a question regarding referrals. You
Yeah.
stated that, so I have a question regarding agent referrals. Do we have to tell anybody regarding, you know, compensation from another agent or company based on a disclosure? And who's responsible for disclosing? Is it the one referring or the one receiving?
So let me be sure I understand it. So, I mean, you're splitting commission between the buyers and seller side is, you know, always in, you know, in the transactional documents. Are you saying that another, like your friend in Coldwell, who's also in Coldwell Banker George, referred you to this
Yes.
client, or your
Let's-
friend at Keller Williams or some other office, or?
Yes, say for example, it's out of area, so I referred a client to somebody else in another area. They could be Coldwell Banker or they could be another company, but yeah, so it's either I'm receiving a referral or I'm giving a client to somebody else. Does that make sense? It's a common practice.
So,
with
I mean,
agents. If we can't service clients, we give them to somebody
right,
else,
of
but we
course, of
receive
course.
compensation.
I mean, if I understand you correctly, I don't think you need to disclose that to anyone. So if you have a buyer who's looking for a house in San Diego and you refer them to an agent down there,
Correct.
and then they find their agent down there, and then that agent when that escrow closes, that agent does a favor for you or pays you some fee, gives you something.
Correct, because I gave them the name of the San Diego
I don't
agent.
think you have, no, I don't think you have to do anything with that. And then
Okay.
the reason I say that is because that buyer, they were never really your client for that transaction.
Correct.
So you're just referring them. I mean, your duty as their agent, your fiduciary duty of their agent begins when they sign their offer, or begins when escrow opens and ends when escrow closes. So no, you referring them to another agent in San Diego, or even an agent, they want to buy a house in Palos Verdes and you really know Pasadena. You've got a friend who's the expert in Palos Verdes. You refer them to that agent. When that escrow closes, you get a payment from that agent. I don't think you have to disclose that or do anything with that.
Thank you.
How do you have to disclose that? He gave some repair and.
So that agent gets it from them. Well, I mean, first of all, that buyer is going to know that when that buyer comes to the agent in Palos Verdes, maybe that the agent in Palos Verdes is going to say, "Oh, great, how did you hear about me?" Right? So therefore, they're going to know of the connection through that. And I still don't think that. So when that agent down in that other city later on does a favor for you or pays you something, I don't think that has to be disclosed to anyone either. No.
I believe the disclosure is gonna come at the very end of the closing statement, because escrow is gonna need that commission referral agreement.
Okay.
And that's where it would be paid out, so the end client will ultimately see, both seller and buyer are gonna see where the commissions are being paid to, so it will be disclosed.
Okay.
It's
And
transparency.
yeah, sure. I mean, the usual rule is that anything you earn out of a transaction should be on the settlement statement. So, yeah.
I have another question. This is
Oh,
Camelia.
hang on one second. You asked her.
Okay, so I don't know if this is in connection with someone. So let's just say there's an offer that comes in that all contingencies removed. And the
That shouldn't
seller-
even happen though, but,
Hmm?
I cut you off. My mom, I had like a heart attack when I heard you say that though, but,
It happens. Let's say they have an all contingency.
okay. Oh, in the offer, when it's made?
When it's made.
Okay.
The seller accepts that, so all contingencies are removed. So that would mean that the disclosures they look at, anything SPQs, anything else they look at, received from the seller, they can see it, but they've already removed all contingencies.
Right.
They can't even back out.
Right.
That,
Right.
but let's just say now, they've looked at all that. But then later on, they find out there was a death on that property, but it wasn't disclosed on the SPQ or any other disclosure. Now, is there any kind of retract or for the
Well,
buyer, because it wasn't disclosed in disclosure, it was discovered later that there was a death.
so I go back to where I said I kind of had a heart attack when I heard that situation, because I mean, and here at Coldwell Banker George, usually you're representing buyers of single family residences, of homes in in this part of Los Angeles County. So you're representing that family looking for their house. They should always have an inspection contingency. And unless they're, you know, pretty wealthy paying all cash, they should always have that loan contingency. So I think the new purchase agreement has on the right side of the page, a statement that says, I don't have, yeah,
For disclosure.
I think the current purchase agreement has on the right side of the page, it says that removing all contingencies at the time of the offer is against the advice of the agent. So it's like CAR telling you, don't do this, you know, so yeah, your Coldwell Banker George transactions, they should always have those investigation and loan contingencies. And, you know, if your client, I mean, I might sound extreme saying this, but you may not even want to go ahead with them if they don't, you may not want to represent them if they don't have those contingencies. And if they really want to remove them that early, be sure you have an email where you're stating to them, I recommend that you have the investigation contingency. I recommend you have the loan contingency, so.
Yeah, that's why they CAR has a new form in 2020.
Right.
So to that effect, and specifically advise the
Exactly.
buyer, you know, if they want to remove all the people question, legal, the.
Exactly, yes, exactly.
I think
Yeah, I
this
mean,
is-
I do advise that. What
Right.
I'm saying is that happens.
Right,
So what if the buyer says, okay, well, I didn't know there was a death on property and that wasn't any of the disclosures I received anyway, so can I back out now?
you know, so death on the property is a unique situation. There is a code section that says a death on the property within the last 3 years has to be disclosed. So I think in your unique hypothetical, I think even though it's not on the TDS, your buyer would still have a claim against the seller because there's a specific statute. There's a specific law that just says seller must always disclose a death on the property in the last 3 years. And it's really doesn't even impact the TDS. It's what as lawyers call it, it's like per code by statute, you've got to disclose that, so.
But even on the worst case scenario, they still backed out with removing all contingencies. They're if the box is checked or initialed by both seller and buyer, the liquidated damage would only be 3%, right?
Correct, yes.
So if they deposited more than 3%, that's due refund to the buyer, right?
Yes,
Hypothetically.
yes.
But most of the time, when you see they're moving all contingencies, that's when investors are coming in buying the property as is.
Right.
You don't normally see that too much, at least I haven't. When someone would want to buy the property to live in.
Correct, yes.
So,
yes.
you know,
Well, that was happening a lot during the pandemic when you just started.
Right.
It's calmed down a lot,
Right.
you know, in order for
I
people
haven't
to,
seen it.
yeah, it were those bidding wars and that's the only way that sellers would, you know, go into contact with buyers. If they would move opportunity.
I mean,
Yeah.
you're allowed to adjust the contingent. I mean, so you gotta have a contingency. You can play around with the length of the contingency. I mean, you could make, you could make it a 10-day contingency. I think, maybe the form says 17 days, you can make it 20 days, you could make it 12 days. You can shorten or extend the contingency period.
In my opinion, there's only two reasons why a seller would want that. One, insurability, or there's something wrong with property, right?
That's right.
Right, yeah. Yeah, I mean, your seller would want shorter contingencies, yeah.
This one last question regarding
There's that.
regarding this,
You know.
documentation,
Yeah.
stating of the files and documentations. I'm representing let's say the seller, and the seller, complete a TDS, and you said there's some report of, whatever, remodeling or. So we are obligated to give a copy of the report of done to the buyer, right? Of those copies. right?
Let me be, I'm not sure I understand the
Repairs, copy.
So it was. Your seller has a report
Yeah.
related to the property,
Yes.
so that should be provided to the buyer. Yes,
All the renovations or report or inspection done should be provided.
like a plumber comes and does a repair, he gives you a receipt or an invoice. I mean, I'm not saying that has to be provided to the buyer, you might just say there's prior replumbing repairs to the bathroom, but you don't have to give the receipt that you wrote to the plumber, but a geologist came and evaluated the soil stability of the property and prepared a typewritten report, that does have to go to the buyer.
And those within how many years?
And there isn't any bright line rule. There isn't a magic number of years. I mean, it depends on what's the condition, how severe it is, you know, what the report says. But you know, the more serious the issue, the go farther back. I usually go with 10 years as the gray area as to how long you have to provide things. But if you've got a report from 15 years ago that says there's pollution in the air from the factory down the street, yeah, then still provide that. If you've got a report that says the hillside is unstable, and that's from 17 years ago, you still need to provide that. But I mean, if you have a termite report from 17 years ago, I think that's too long. So,
Thank you.
I'm sorry to interrupt, Brian. I know all of you have still a lot of questions in mind, but it's totally impossible to cover all the issues of the risk management in 1 hour. And it's already half an hour over time, so
Okay.
I don't want to burden Brian with more. Yeah, very educational, and thank you so much, Brian.
Very good.
And you have Brian's information in the handout. Anytime you have questions, you're welcome to call him. And also have the
Sure.
email, and you can also email him too. And who knows, if there's a popular demand, we can ask him to come back a second time.